Yes. Good afternoon, students. Welcome to Siddhartha IAS. Well, in this lecture, we are going to continue with types of majorities. We have already discussed the absolute majority. We have discussed about the simple majority. We have also discussed about the effective majority. And we were discussing about the special majority. In that, we have seen that the special majorities are of three types, right? As mentioned, as incorporated in the Constitution. And that is special majority of first kind. First kind or first type, one and the same. What is this majority? That is majority of not less than 2/3 of the members of each house present and voting. What is this special majority of first kind? Majority. Wait. Yes. Majority of not less than 2/3 of the members of each house present and voting, right? This is and where this special majority is used, this special majority is used at two places, right? It is mentioned under Article 249. No. This is mentioned under Article 249 and Article 312. 249 is the resolution required for the Rajya Sabha to empower the Parliament to make any of the laws on the subjects enumerated in the state list. And the resolution to be passed by Rajya Sabha under Article 249 requires this kind of majority. Majority of not less than 2/3 of the members of Rajya Sabha present and voting. Okay? And then Article 312 is about all India services, creation of all India services. Even for creation of all India services, the resolution to that effect has to be passed by the Rajya Sabha. And Rajya Sabha has to pass a resolution for that purpose, for creation of one or more all India services. And for that, Rajya Sabha would require resolution to be passed by this kind of majority, right? Special majority of first kind. But ultimately, the all India services would be created by the law of the Parliament, which requires only simple majority. It is only that the Rajya Sabha has to pass the resolution by the special majority of first kind. This we have already seen. Then second is special majority of second kind. Second kind. What is it? What is it? This is majority of total. Majority of total membership or total strength of each house and what? And majority of, yes, majority of not less than, yes, 2/3 of the members of that house present and voting. Remember, in the special majority of first kind, this requirement is not there. Majority of total membership of each house. The special majority of first kind only involves majority of not less than 2/3 of the members present and voting, right? So the special majority of second kind is nothing but absolute majority plus special majority of first kind, because this is what majority of total membership or total strength of each house is absolute majority, right? 272 in case of Lok Sabha and 120. What is the absolute majority in Rajya Sabha? It is 272. It is 272 in case of Lok Sabha. And what about Rajya Sabha? What is the what is the total? What is the absolute majority in Rajya Sabha? Yes. No. How will you calculate? 245 divided by 2 plus 1. What is it? 123 or more, right? Or 122. Is it 122 or 123? Calculate. It is 123, right? 123 or more. So this is what is the first requirement. And second requirement is special majority of first kind. That is majority of not less than 2/3 of the members present and voting. Yes, first is absolute majority. Second is special majority of first kind, which we have just seen, right? So we can say that special majority, we have seen this already. Special majority of second kind is equal to what? Is equal to absolute majority. Yes. Plus special majority of first kind. As simple as that. So which is difficult to get? The special majority of first kind or special majority of second kind? Second kind. Why? Because here absolute majority is also required. Right? Fine. Now let me give you example of the special majority of second kind. Suppose, what is the total strength of Rajya Sabha? It is 245 in case of Rajya Sabha. Now out of 245 members, on a given day, only 190 members, they are present. So how many are absent? 55 are absent. And suppose the total strength of Rajya Sabha is 245. There are no vacancies, right? So suppose on a given day only 190 are present, 55 are absent. Now out of 190, only 183 vote on that particular bill or resolution or motion, whatever it may be, right? Right? Okay? Mainly it is a resolution or a bill, constitutional amendment bill, right? Now, so it means that how many are abstaining? 7 are abstaining. 7 abstain. They come to the house, but they do not participate in voting. So now 183 members, they vote in favor of, say, particular resolution, right? Now tell me, what is the absolute majority required in this? What is the special majority of second kind that will be required? Now first condition is that it should have absolute majority of Rajya Sabha. What is the absolute majority of Rajya Sabha? It is 123. So out of 183, 123 members should vote in favor of that particular resolution, right? And what would be the 2/3 of 183? Calculate 2/3 of 183. 2/3 of 183. 183 into 2 divided by 3 plus 1. You have to add plus 1. What is it that? Calculate. If you calculate, it will be 122. See? Calculate it now. 183 into 2 divided by 3. Calculate. Yes? So now here, you have to remember that this bill has got the absolute majority, 123, right? 123, if only 122 members, if they vote in favor of the bill, then that is not sufficient. 123 members should vote, because we need absolute majority as well as the majority of 2/3 of the members present and voting. So here, if only special majority of first kind is there, then the bill will be passed, 122. But we need number 123. So we need minimum 123 members of Rajya Sabha who should vote in favor of that bill, irrespective of this number. Okay, right? Fine. Now let me give you another example, right? See, suppose Rajya Sabha, let me give once again, I'll explain this example. Rajya Sabha has 245 members, I've told you that out of 245, only 190 are present. Out of 190, 183 are voting. Now, if that particular resolution has to be passed, what is the absolute majority that is required? Absolute majority that is required is 123. And what is the special majority that is required? 122. So, here absolute majority is more than the special majority of first kind. So, minimum 123 members of Rajya Sabha should vote in favor of that bill. Right? So, only having 122, only satisfying the special majority of first kind is not enough. Along with that, absolute majority is also required. On a given day ऐसा हो सकता है ना, suppose 245 में से सिर्फ 122 ही लोग present है. Suppose out of 245, 122 members they are present and they vote in favor of, and all of them they vote in favor of the bill. But still that bill will be defeated. That resolution will be defeated. Why? Because absolute majority requirement has not been fulfilled. Got it? Right? Let me give you another example. That is Lok Sabha. What is the absolute, what is the total strength of Lok Sabha? It is 543. Now suppose out of 543, only 300 are present. Only 300 are present and they vote. Now what will be the requirement for that particular resolution to be passed? What will be the requirement? First is absolute majority. That is 272 or more. Okay? And what is the 2/3 of 300? Calculate. 300 into 2 divided by 3. Calculate. Huh? Calculate. 100 into 2. 200. So here also, having only 200, so here the majority of not less than 2/3 of the members present and voting, this condition has been satisfied. But this condition also has to be satisfied. So out of 300 members present and voting, 272 members or more, they should vote in favor of that resolution. Then only that will be passed. Got it clear? ठीक है? तो इसमें कितने लोग प्रेजेंट है और वोटिंग है ये ज्यादा मैटर नहीं करता है, unless and until this requirement is met, right? So special majority of first kind requires support of minimum of 272 members of Lok Sabha and 123 members of Rajya Sabha. These many members must be present and they must vote in favor of that particular resolution. Right? Irrespective of the fact that how many are, and out of those who are present and vote, out of that 2/3 of the members present and voting, they should vote in favor of that resolution. Both the conditions should be met. If only one condition, that is majority of not less than 2/3 of the members present and voting is met, and the first condition is not met, then the bill will be defeated. That is why it is difficult to get. Whereas in the case of special majority of first kind, it is very easy to get. Why? Because suppose on a given day in Lok Sabha, on a given day suppose ये 543 में से सिर्फ 200 भी लोग present है ना, उसमें से 2/3 लोग अगर वोट कर रहे हैं, तो वो बिल पास हो जाएगा. Right? So that's why special majority of second kind is little difficult to secure as compared to the special majority of first kind. Right? समझ में आया? So for Article 249 and under Article 312, special majority of first kind is required. Absolute majority is not required along with the special majority of first kind, right? ठीक है? That is required in the special majority of second kind. समझ में आया आपको? Right? हाँ. Now where it is required? Where it is required? ठीक है? So it is required at 4 places. Special majority of second kind. First kind we have already discussed, right? 2 places. Yes. So first is constitutional amendment bills. Under Article 368. Yes. Right? There are certain provisions of the constitution under Article 368, they require special majority of second kind, which is mentioned in Article 368. Okay, we are going to discuss the amendment of the constitution after this, after we finish with this. But this is the first case. There are certain provisions of the constitution which require special majority of second kind. Right? For example, fundamental rights. If fundamental rights under Part 3 are to be amended, then this particular majority would be required. Directive principles of state policy, if they are to be amended, okay, then this majority would be required. Okay? Fourth schedule. If fourth schedule of the constitution is to be amended, right, then also this is required. But remember, if there is any amendment to the fourth schedule which deals with allocation of number of seats each state has in Rajya Sabha, if amendment to the fourth schedule is due to admission or establishment of new states under Article 2, or formation of new states, or alteration of area boundaries and names of the existing states, then that will require only simple majority. But apart from that, the fourth schedule requires, apart from that specific condition, fourth schedule will require. Yes, because that is why they require, right? So see, we cannot say that fourth schedule requires special majority. No, there is one exception to that, and that is if fourth schedule is getting amended due to Article 2, anything done under Article 2 and Article 3, then that will require only simple majority. But apart from that specific situation, fourth schedule will require special majority, right? So fundamental rights, directive principles of state policy, fourth schedule, so on and so forth, right? So certain constitutional amendment bill requires special majority under Article 368, right? And this type of majority is mentioned in Article 368, by the way. Okay? Second, now I've told you about the types of emergencies under Indian Constitution. I told you about national emergency under Article 352, then President's rule under Article 356, and financial emergency under Article 360. Now, while discussing simple majority, right, I have told you that for disapproval of the continuance of the national emergency, simple majority is required, and that too in Lok Sabha. Then approval of President's rule or its continuation after every 6 months also requires simple majority. And approval of financial emergency also requires simple majority in both the houses of parliament. Right? And once financial emergency is approved, it can be extended, it is extended indefinitely unless and until it is revoked by the President of India. Right? So disapproval of the continuation of national emergency requires simple majority, but only in Lok Sabha. Then approval or continuation of President's rule requires simple majority in both the houses of parliament, right? And approval of financial emergency also requires simple majority in both the houses of parliament. But what about approval of national emergency and continuation of national emergency? Now this requires special majority. Approval of national emergency or its continuation okay, under article, which article? 352, right? So this is the second place where the special majority of second kind is required. Approval of national emergency. See, whenever national emergency is proclaimed by the President of India, it has to be approved by both the houses of parliament within 1 month from the date of proclamation of national emergency by both the houses of parliament, and that requires special majority of second kind, that is majority of the total strength of each house and majority of not less than 2/3 of the members present and voting, right? Okay? And even continuation. See, once national emergency is approved by both the houses of parliament by special majority, it continues for 6 months at a time. So every 6 months it requires parliamentary approval, and that parliamentary approval also requires special majority of second kind. Got it? Fine. Number 3. Now, there are certain constitutional offices, those who are holding certain constitutional offices, their removal also requires special majority of second kind. See, let me tell you. Removal of judges of Supreme Court and High Court, removal of Comptroller and Auditor General of India, and removal of Chief Election Commissioner of India. Now, judges of Supreme Court and High Court, right? Chief Election Commissioner of India and Comptroller and Auditor General of India, CAG. If they are to be removed, then the resolution has to be passed in both the Houses of Parliament. This resolution has to be passed by special majority of second kind, and after this resolution is passed, then the resolution will be sent to the President of India, and President of India would remove the judges of Supreme Court or High Court or the CAG or CEC, as the case may be, right? So resolution required to be passed for removal of judges of Supreme Court, judges of High Courts, CAG and CEC. It requires special majority, okay? So resolution to be passed by Parliament, both the houses, for removal of both judges of both Supreme Court and High Court. Removal of, yes, judges of Supreme Court and High Courts, comma, Comptroller and Auditor General of India is a constitutional body, and Chief Election Commissioner. Remember, Chief Election Commissioner and not the election commissioners. Chief Election Commissioner. Because the other election commission is a 3-member body. The other election commissioners, they can be removed by the President of India merely on the recommendation of Chief Election Commissioners. But to remove the Chief Election Commissioner itself or himself, right, the special majority of second kind is required. Okay, right? So resolution to be passed by Parliament for removal of judges of Supreme Court and High Courts, Comptroller and Auditor General of India, and Chief Election Commissioner. But ultimately, who will remove? Who have power to remove these offices? No, it is the President of India. But President of India cannot remove the judges of Supreme Court or High Court or CAG or CEC on his own discretion. Before he removes, he requires the resolution to be presented to him, and that resolution has to be passed by both the House of Parliament by special majority of second kind. That is majority of the total strength of each house and majority of not less than 2/3 of the members present and voting. Got it? Right? So this is the third place. And fourth place, where the special majority is required, is mentioned under Article 169. Now what is Article 169? Right? Now Article 169 is about, let me write down here. Okay? Article 169. Article 169 is about abolition of Legislative Council. Legislative Council. Abolition of Legislative Council in states having such council. Or creation of Legislative Council in states not having such council. This is provided under Article 169. Now remember that the Constitution of India provides for bicameral parliament, bicameral legislature at the central level. Bicameral means having two houses. So at the central level, Constitution of India provides for bicameral parliament. Right? For example, the Parliament of India consists of President of India, Council of States and House of the People. So we have Constitution provides for bicameral parliament at the central level. But at the state level, Constitution does not provide for bicameral legislature in all states. Constitution only provides or constitution only provides bicameral legislature in 6 states. Now, what are the two elements of bicameral legislature at the state level? One is state legislative assembly and other is called as legislative council. State legislative assembly, lower house, Vidhan Sabha. Legislative council, upper house, Vidhan Parishad. So only 6 states they have the legislative council, right? Which are the 6 states? I've told you, UP, Bihar, Maharashtra, Karnataka, Andhra Pradesh, Telangana. These are the 6 states which have currently legislative councils, right? And even before 2019, even Jammu and Kashmir, the then state of Jammu and Kashmir also had legislative council, but the legislative council of Jammu and Kashmir was abolished through Jammu and Kashmir Reorganization Act 2019, right? So currently we have only 6 states. No, before that 7 states, before 2019 Act, 7 states had legislative council, but presently we have only 6 states, right? I've told you about 6 states. Okay. Now, Article 169 provides for the procedure for abolition of legislative council or creation of legislative council in states which does not have that. Okay. Now, Article 169 states that Parliament may by law provide for abolition of legislative council in states having such legislative council or abolition of legislative council, creation of legislative council in states which does not have such legislative council, provided state legislative assembly passes a resolution to that effect by the special majority of second kind. That is majority of the total strength of legislative assembly and majority of not less than 2/3 of the members of assembly present and voting. Right? So what is the procedure for abolition of legislative council in states having such legislative council and creating legislative council in states not having such council? What is the procedure? First is that the resolution to that effect has to be passed by special majority of the second kind by state legislative assembly concerned, and then after Parliament has to pass a law, and that law has to be passed only by simple majority. Right? So there are 2 steps involved. First step kya hai? First step is, okay, write down this. Okay? So what is the first step? First step is required is that resolution has to be passed by the state legislative assembly, and that resolution require special majority of second kind, and thereafter Parliament, that resolution will be sent to the Parliament, right? And the Parliament may create or abolish the legislative council by simple majority. That is majority of the members of each house present and voting. Remember, it is not mandatory for the Parliament to create or abolish the legislative council once the resolution has been passed by state legislative assembly. After state legislative assembly has passed the resolution for creation or abolition of legislative council, whatever it may be, it is up to the Parliament whether to accept that resolution or not. So ultimately, Parliament of India has power to abolish the legislative council or create the legislative council. But the process for abolition of legislative council or creation of legislative council can be initiated only by the state legislative assembly. Right? It is only after state legislative assembly pass the resolution by special majority of second kind, then only Parliament may by law create the legislative assembly or abolish the legislative assembly. Got it? It is very important to understand. For example, in 2014, legislative assembly in Telangana was created. How it was created? It was created through simple majority. It was created through simple majority, right? Andhra Pradesh Reorganization Act. How the legislative assembly of Jammu and Kashmir, the then state of Jammu and Kashmir, was abolished by Jammu and Kashmir Reorganization Act, which was passed by simple majority, right? So the abolition of legislative council in the states having such council or creation of legislative council in states not having such council, right? It requires first special majority in legislative assembly, and then the Parliament may create for legislative assembly or abolish legislative council only by simple majority. So because there was no legislative assembly, no, the Jammu and Kashmir was under the president's rule and the assembly was kept in suspended animation. So there was no requirement of the special majority of second kind to be passed in the legislative assembly because there was no legislative assembly. It was in suspended animation, right? Yes, then the special majority would have been required in the Jammu and Kashmir Legislative Assembly. Okay, so which are the two steps required? Number one, first, the resolution has to be passed by Legislative Assembly of state concerned by special majority of second kind. Write down the special majority of second kind क्या है वो लिखना है आपको. In exam don't write special majority of second kind. Constitution nowhere mentions that there are three types of special majority of first kind, second and third kind. Right? I am telling you just for the sake of understanding. Constitution में ये mention नहीं किया है. ठीक है, यहाँ पे लिखो ना, concerned by majority of the total strength of each house and majority of the total strength of legislative assembly and majority of not less than 2/3 of the members of legislative assembly present and voting. Instead of writing second kind, write that majority itself. Okay? So this will be the first step, and then second what? Parliament may by law create or abolish legislative council by what? By simple majority. Now hear me again. Suppose the state legislature concerned has passed the resolution by special majority of second kind for creation of legislative council. It has passed the resolution. The resolution will be sent to the central government, and it is not necessary that the central government or parliament has to compulsorily pass the law and create the legislative council. No, it is not binding. The resolution passed by the state legislative assembly is not binding on the parliament. Parliament may or may not accept the resolution, right? It is same as under the Article 3, right? For formation of any bill for formation of new states or alteration of area boundaries or names of the existing states. In order to do that, the bill has to be introduced in any house of the parliament, but this bill can be introduced only with prior permission of the president. Before president gives permission or recommendation to introduce that particular bill, the bill will be sent to the state legislature for its opinion, and the state legislature's opinion is neither binding on the president not on the parliament. Same is the case here. तो जरूरी नहीं है कि स्टेट लेजिस्लेटिव असेंबली ने रेजोल्यूशन पास किया है क्रिएट करने के लिए, अबॉलिश करने के लिए, तो पार्लियामेंट कंपलसरी ये है. फॉर एग्जांपल लेट मी टेल यू, राजस्थान असेंबली पास्ड resolution, this resolution by special majority, by majority of the total strength of Legislative Assembly of Rajasthan and majority of not less than 2/3 of the members present and voting, okay, in 2013. But the bill for creation of the Legislative Council in Rajya Sabha is still pending in the Parliament, okay, right? Then another example, recent example मैं बताता हूँ. January 2020 में आंध्र प्रदेश Legislative Assembly, it passed the resolution by special majority of second kind for abolition of Legislative Council in Andhra Pradesh, because Andhra Pradesh has Legislative Council. The Legislative Assembly said that we don't want Legislative Council. Now, it is not as if the moment Andhra Pradesh Legislative Assembly has passed that resolution, the Legislative Council has abolished. No, even today, Andhra Pradesh has Legislative Council. Why? Because Parliament has not taken any action on abolishing the Legislative Council in Andhra Pradesh, because Parliament has to bring in the bill, government has to introduce the bill, and that has to be passed by simple majority in both the House of Parliament. Then only the Legislative Assembly in Andhra Pradesh can be abolished. Right? समझ में आया किसके क्या रिस्पेक्टिव पावर्स है? स्पेशल मेजॉरिटी ऑफ सेकेंड काइंड इज रिक्वायर्ड ओनली इन स्टेट लेजिस्लेटिव असेंबली. आफ्टर दैट पार्लियामेंट मे बाय लॉ provide for creation or abolishing the legislative council, and that requires only simple majority. So these are the four places where the special majority is required. Okay? Which are the 4 places I told you? Yes. Let me revise. Number 1, constitutional amendment bills under Article 368. Then resolution to be passed for approval or continuation of national emergency. Third, resolution to be passed by both the houses of parliament for removal of judges of Supreme Court and High Courts, Chief Election Commissioner, and Comptroller and Auditor General of India. But remember, ultimately, who will remove these authorities? President. But President cannot remove without the resolution to be passed by both the House of Parliament by special majority. Right? And then finally, resolution required to be passed by State Legislative Assembly for creation or abolition of Legislative Council under Article 169. These are the 4 places where special majority of second kind is required. Got it? Remember this. Now, special majority of third kind. This is, write down, majority of not less than 2/3 of total strength और total membership. दोनों एक ही है expression. Both expression, total strength or total membership. Or both the houses of parliament. You can write down this. Special majority of third kind. I repeat, Constitution nowhere mentions about special majority of first kind, second kind, and third kind. I have divided this for the purpose of clarity, for understanding. Okay? Now, what is special majority of third kind? Majority of not less than 2/3 of the total strength or total membership of both the houses of parliament. Now, this is very interesting. देखिए, majority of not less than 2/3 of the total strength or total membership of both the houses of parliament. Now, what does it mean? Let me explain. Got it? Did you write down? Okay, fine. Good. Now, what is the special majority of third kind? Practically speaking, okay? Now, special majority of third kind. Let us discuss this in Lok Sabha and Rajya Sabha. First, Lok Sabha. What is the total strength of Lok Sabha? Total strength or total membership, one and the same, irrespective of vacancies, right, or abstentions, is equal to, what is? 543. So what will be the special majority of third kind in Lok Sabha? It will be 543 ka 2/3 plus 1. Right? More than, not less than 2/3 of the members. 2/3 of the total strength. Remember, present and voting doesn't matter. So special majority of third kind will be calculated out of the total strength, that is 543 in Lok Sabha. Calculate this. If you calculate, you will get this number, 363 or more. Calculate. Yes, obviously. Calculate. 543 into 2 divided by 3 plus 1. It would be 363 or more. So, to pass this special majority of third kind, the support of at least 363 members of Lok Sabha is required. Yes, is it 363? Calculate karo. 543 into 2 plus 1. 363 plus 1. Don't forget plus 1, right? So special majority of third kind in Lok Sabha is always fixed. It is always 363 or more. Special majority of third kind, like absolute majority, will always be fixed. Why? Because what is the difference between absolute majority and special majority of third kind? Absolute majority is majority of not less than half of the total strength of the each house. So it is 272 in Lok Sabha and 123 in Rajya Sabha. Here the difference is not half of the total strength, but 2/3 of the total strength or total membership, right? So special majority of third kind would be always 363, irrespective of number of vacancies or number of abstentions. Doesn't matter कितने लोग absent है, कितने लोग present है, इतने लोगों ने उस particular resolution को pass करना जरूरी है. 363, right? In Lok Sabha. What about Rajya Sabha? I am coming to that. Yes, you are right. What is total strength? Total strength is equal to 245. So what is the special majority of third kind? That is, what is special majority of third kind? The majority of not less than 2/3 of the total strength of house. That is, total strength is 245. So you will calculate 245 ka 2/3 and you will add 1 to that. It would be 164 or more. Calculate this, you will get this number, 164 or more. Yes? Fine. So, special majority of third kind. Okay? In Lok Sabha 363 and in Rajya Sabha 164 or more. Remember, or more, but minimum 363 or more. Okay? Got it? Now where it is used, very important. Now as he rightly pointed out of all the majorities we have discussed, this is the toughest majority to get. Why? Because here the majority is not less than 2/3 and that too of total strength and not present and voting. हो सकता है किसी दिन 300 ही लोग present and voting है. 300 लोग अगर present and voting है तो वो resolution पास ही नहीं हो पाएगा. It will be defeated in Lok Sabha. ठीक है? Now where it is required? This majority is mentioned under Article 61 of the Indian Constitution. ठीक है? Article 61. Article 61 is about impeachment of President of India. Impeachment of President of India. Right? So, President of India can be impeached under Article 61 of the Indian Constitution for violation of on what grounds? What is the ground mentioned? Violation of Constitution. This is, we are going to see it again when we discuss President. Violation of Constitution. Yeah, Constitution nowhere explains or defines what is the meaning of violation of the Constitution. But Article 61 says that President of India can be removed for violation of the Constitution, and to remove President of India, the special majority of third kind is required in both the House of Parliament. So President of India can be removed if the majority of not less than 2/3 of the total strength of both the House of Parliament passes the resolution for that effect. So, agar President of India ko remove karna, if President of India has to be removed, then the resolution has to be passed in both the Houses of Parliament, and that resolution has to be supported in Lok Sabha by minimum of 363 members and in Rajya Sabha by minimum of 164 members. Without that, right? And remember, once the resolution is passed, President is removed from his post. Right? Because that resolution will not be sent to the President. Right? Because the case is of his own removal. So once the resolution is passed by by the majority of not less than 2/3 of the total strength of both the houses of parliament, the president will stand remove, right? The moment resolution is passed, and it requires support of 363 members, at least 363 members in Lok Sabha and at least 164 members in Rajya Sabha. Okay, they must vote in favor of that resolution. Okay, right? And this is the toughest majority which is mentioned under Constitution, that is Article 61. Now here we complete the types of majorities. Got it? Now, ideally speaking, the types of majority topic should have been completed within 2.5 hours. But we took it long. Why? Because while discussing these types of majorities, we also discuss various other provisions of the Constitution. For example, we discuss Article 75 Clause 3, and in that we discuss no confidence motion as well. Right? Even here we discuss Article 169, procedure for abolition or creation of legislative council, and that is why it took time, right? But please revise this particular lecture, the notes of this particular lecture, because it is very, very important. You should know where special majority is required, where simple majority is required, where effective majority is required, and where the absolute majority is required. You should know about this, right? And whenever you read a question about any majority, you need to see what is the, out of what the majority is talking about, whether it is the present and voting or whether it is total strength of the house. You have to carefully read that, because UPSC might give you questions just to confuse you. For example, President of India can be removed by the majority of not less than 2/3 of the members present and voting. Is it correct? It is wrong. Because it is not present and voting, it is majority of not less than 2/3 of the members, total strength of the house. So you have to read carefully, every sentence you have to read carefully. Simple majority है या special majority, कहाँ पे simple majority चाहिए, कहाँ पे special majority चाहिए. Even you should be careful in that. For example, under Article 169, special majority is not required in the parliament. It is required in the state legislative assemblies. And then the parliament may pass the law to that, for that effect, and that requires only simple majority. But ultimately, who has power to create or abolish legislative council? It is the parliament. But parliament cannot initiate the process of creation or abolition of legislative council. Parliament has to wait for the resolution has to be passed by the legislative assembly. Agar legislative assembly resolution pass nahi kiya, parliament cannot create or abolish legislative council on its own. So first condition has to be first met, that is resolution passed by the legislative assembly, and then only the second step will come into picture. Got it? Clear? Types of majorities? Very good. Now let us discuss about the new topic, which is very important. It is related to types of majorities only, and that is, yes, amendment to the Indian Constitution. Now you will, once you understand types of majorities, this topic will be very easy for you to understand. Okay? What? This one? Why? Okay, ऐसे दिखता है, ठीक है. Amendment to the Indian Constitution. This is the topic we are going to study. Remember, I am not following the Lakshmikant ka pattern, neither any book. We are going systematically, right? ठीक है. Now, amendment to the Indian Constitution. Now, many of you might be hearing this word amendment for the first time. So, just to clarify, what is amendment? Okay? In simple words, amendment means change. In what? Amendment to the Constitution. What do we mean by amendment to the Constitution? Change in, don't speak, change in the provisions of what? Of Constitution. So amendment means change in the provision of the Constitution. Be it Indian Constitution or be it any Constitution. Amendment means change in the provisions of the Constitution. What do we mean by provisions? What do we mean by provisions of the Constitution? Provisions of the Constitution include clauses, articles. clauses, sub-clauses, schedules, so on and so forth. That is what we mean by provisions of the Constitution, right? So, amendment to the Constitution means change in the provisions of the Constitution. Now, change in the provisions of the Constitution can be made by three ways. One is by way of what? Addition, right? Addition, you can add any clause, you can add any article, you can add any part, you can add any schedule, right? Addition. Then, no, don't use the word subtraction, it is not mathematics. Addition. Repeal. Repeal means removing that particular article, that particular part, that particular provision. For example, 36th Constitutional Amendment Act repealed Article 2A and 10th Schedule of the Indian Constitution. Remember Sikkim? Okay? Repeal. And what? It can also be changed through variation. Changing the language of the provisions of the Constitution. Right? Not adding or not repealing per se, but just change in the provisions. Right? So, for example, 45. So, the 86th Constitutional Amendment Act changed the language of Article 45, which is in Directive Principles of State Policy. Right? Change in the language. Not adding or not repealing any particular provision, but to change the language. वही article है, उसका language change करना है. ठीक है? Right? For example, let me give another example for this. ठीक है? 61st Constitutional Amendment Act was passed in 1989. It reduced the voting age in India from 21 to 18. So just instead of word 21, the word 18 was replaced. Okay? That is variation. But here there was repeal as well, है ना? ये 21 को हटा के 18 लिख दिया. Replacement. Okay? Right? So what is amendment? Amendment to the Constitution means change in the provisions of the Constitution by way of addition, repeal or variation. As simple as that. This is what amendment means. ठीक है? हिंदी में इसको कहते हैं संशोधन करना. और संशोधन तीन प्रकार से हो सकता है. Addition, repeal and variation. Got it? What do you mean by amendment, right? Now, where the provision about amendment to the Indian Constitution is made, right? So, Article 368 of the Indian Constitution, which is in part 20, right? It provides for two things: power of Parliament to amend the Constitution, through its constituent power, and second, procedure for doing that. Procedure. Right? Article 368 of the Indian Constitution under part 20 provides for amendment to the Indian Constitution. Article 368 states that Parliament has power by virtue of its constituent power to amend the Constitution of India by way of addition, repeal or variation. Okay? Right? In accordance with the procedure as mentioned in Article 368. So Article 368 talks about two things. It's very important to understand, because while we discuss basic structure of the Indian Constitution, the title of 368 was different. Okay? And later on the title was amended. So that is why it's very important to understand. Article 368 talks about power of Parliament. What is the title of Article 368 at present? Okay? Write down this title. Power of Parliament to amend to amend the constitution and procedure therefore. No, procedure thereof. Procedure thereof. This is what the exact title of Article 368. Power of the Parliament to amend the Constitution and procedure thereof. Okay? And Article 368 says that Parliament has power by virtue of its constituent power. Now, what is constituent power? See, under the Constitution of India, Parliament enjoys two types of legislative powers. One is constituent legislative power and second is ordinary legislative power. Right? Parliament under Constitution enjoys two types of legislative powers, law-making powers. One is constituent legislative power and another is ordinary legislative power. Right? By using ordinary legislative power, Parliament makes various laws. Right? So laws made by the Parliament by using ordinary legislative powers, they are called as ordinary laws. Right? And laws passed by the Parliament by using its constituent legislative power, they are called as constitutional amendment acts. Right? Ordinary laws and constitutional amendment acts, these are different. Ordinary laws are passed by simple majority. Right? Okay? And constitutional amendment acts under Article 368 requires special majority. Right? Okay? Different. समझ में आया? I repeat, this is very important to understand. Again, this will be very important when we discuss the basic structure doctrine, right? This is what Supreme Court said in Shankari Prasad versus Union of India case of 1951, right? So, Parliament under Constitution enjoys two types of legislative powers. One is ordinary legislative power. Now, this ordinary legislative power is outside Article 368. Outside Article 368, and constituent legislative power, it is under Article 368. The laws made by the Parliament by virtue of its constituent legislative power, they are called as constitutional amendment acts under Article 368, and laws made by the Parliament by using its ordinary legislative power, they are called as ordinary laws. Okay? Okay, fine. समझ में आया? कॉन्स्टिट्यूएंट पावर मतलब क्या होता है? कॉन्स्टिट्यूएंट पावर, आर्टिकल 368 मेंशंस दिस कॉन्स्टिट्यूएंट पावर. कॉन्स्टिट्यूएंट पावर मीन्स पावर ऑफ पार्लियामेंट टू अमेंड द कॉन्स्टिट्यूशन. हाउ? बाय वे ऑफ what? Addition, variation and repeal, or repeal. ठीक है? Under Article 368. Got it? What is constituent power? Right? Yeah, write down this. What is constituent power? Sometimes UPSC might ask you question. What do you understand by the term constituent power? The way it has asked what is constitutional morality. Okay? UPSC always focuses on basics. Okay? It always asks basic questions. But what we do, we focus more on factual things. And in that hurry, or in that craze for collection of facts, we do not focus or we ignore the concepts, right? So conceptual understanding is very important. Okay? Constituent power, right? Now this is about Article 368. Now the question is, you might ask, why? why do we need amendment? Why do we need amendment to the Constitution? After all, see, this is the question. Why do we need? After all, Constitution was made by those people who were committed towards the welfare of India. They were men of impeccable integrity. They were forefathers of our Constitution. They were extremely talented people. They had impeccable integrity. They had high moral standards. Now they have made the Constitution. Then why do we need the amendment to the Constitution made by such experts? Right? This is the question. Now understand that, why you're late? Alright, so understand that why do we need amendment to the Constitution? See, you might say that the Constitution was framed by, the outstanding people. But even the founding fathers of Indian Constitution, they were aware about the need to amend the Constitution in accordance with the changing needs of time and circumstances. Even they were aware, and that is why they added Article 368 in the first place. They themselves wanted that Constitution should be able to change in accordance with the changing needs of time and circumstances. And that is why they added Article 368. They did not want to make Constitution as a final word on everything. They did not want to make the Constitution rigid and inflexible and permanent. No. Because by its very definition, Constitution is a dynamic document. Constitution is a dynamic and it is living document or organic document. It is not a static document. Constitution is not a final word on everything and anything. You cannot make Constitution final. No. Why? Because the needs and circumstances in which the Constitution was made in 1950, those needs and circumstances might be different than today's needs and circumstances. Right? So, by its very nature, Constitution is dynamic. Constitution is a living document. It is not dead document. It is a living document. So, like a living organism, it continuously evolves over a period of time. It continuously grows, and it has to grow. If you make Constitution static, you are making the dead Constitution. You are making the Constitution which is going to be redundant and useless in future. So, amendment is the basic requirement for any Constitution. You look at any Constitution across the world, they had been amended once they have been made. Right? So, Constitution cannot be a final word on everything. Constitution, by its very definition, is a dynamic document. We need to have flexible when it comes to changing the Constitution. Constitution has to change. Those constitutions which do not change in accordance with the changing needs and conditions and circumstances, those constitutions are going to become redundant and useless and meaningless. People are going to overthrow that Constitution. People are not going to abide by that Constitution if you make that Constitution static. Right? So, even Jawaharlal Nehru, in the Constituent Assembly, he said that there cannot be, even though we want Constitution as to be as permanent as possible, but you cannot make Constitution rigid or permanent for forever. Jawaharlal Nehru said that, there cannot be a permanence in the Constitution. Yes, we want that Constitution once framed, it should last longer, but Constitution cannot be permanent or rigid. There has to be flexibility in the Constitution in order to enable that Constitution to be changed in accordance with the changing needs and circumstances. He said that if you if you make the constitution rigid and permanent, then you are going to, you are basically opening the death knell of the constitution. You are stopping the growth of the nation. If you make the constitution permanent and rigid, then it amounts to stopping the growth of nation, which is organic entity of living people. So nation is dynamic. So the constitution which governs that nation, it has to be dynamic. It cannot be static, it cannot be rigid, it cannot be permanent, it has to be flexible. Even Dr. B.R. Ambedkar, he argued that while participating in Constituent Assembly debates, he argued that we cannot put seal of infallibility and finality in the constitution. We cannot put the seal of infallibility, that as if the forefathers of the Indian constitution, they have not made any mistakes. No. So we cannot make constitution the final document without any possible of being changing in future, right? So we have to make, so that's why he said that the drafting committee has avoided of putting the final seal of infallibility and finality on the constitution. Constitution is not infallible. There might be mistakes in the constitution. There might be inadequacies in the constitution, right? And those inadequacies should be able to change. For example, you might say that there were so many inadequacies in the constitution. For example, Article 356. Article 356 leaves enough scope for its misuse by the central government. It is inadequacy in the constitution. Definitely it is there. Then when it comes to the emergency provisions, all the types of emergency provisions, they require only simple majority for their approval, and it was misused. And that is why 44th Constitutional Amendment Act was passed in 1978, which provided the provision of special majority for approval or continuation of the national emergency. Original Indian Constitution only provided for simple majority for approval of national emergency or its continuation. And the period was mentioned 2 months. It was reduced to 1 month by 44th Constitutional Amendment Act 1978. There were many directive principles of state policy which were added later on. For example, 44th Constitutional Amendment Act, 42nd Constitutional Amendment Act 1976, it added 4 directive principles of state policy, right? Article 39A, Article 43A, right? For 39A is about equal justice and free legal aid to poor. It should be there, but it was not there. Fundamental duties were not mentioned in the constitution itself. They were added through amendment. So constitution cannot be infallible. Yes, it is a supreme law of the land. It is the fundamental and paramount law of the land. But even the constitution can have its inadequacies. And if today, if I frame a particular document, and if I look at the document 50 years down the line, I will definitely find that document has some lacunas. Because I have written that document considering the today's needs and circumstances. Your UPSC notes which you have made for 2021 might not be useful for 2023 or 2024 attempt. You have to change it, you have to adapt. So similarly, constitution also had to be it has to be adapted in accordance with, it has to change in accordance with the changing needs and times and circumstances of the country. Yes, there were various constitutional amendment acts were enacted. I mean, you can say that some amendments were not necessary, but there were some amendments which were absolutely necessary. 73rd and 74th Constitutional Amendment Act. At that time, when Constitution was being framed, Jawaharlal Nehru and Dr. B.R. Ambedkar, they opposed giving constitutional status to Panchayati Raj institutions and urban local bodies. Why? Because they felt that the time has not yet come for giving the constitutional status to Panchayati Raj institutions and urban local bodies. Why? Because India's social structure is casteist, it is unequal. And we have the priority in front of us is the unity and integrity of the nation. We want people to think in terms of national goals. We cannot make people parochial in thinking about their own local areas. But the situation changed after 40 years. And that is why in 1992, the 73rd and 74th Constitutional Amendment Act were enacted. At that time, it was found that it was not necessary. Dr. Ambedkar was extremely critical of Panchayati Raj institutions. He said that what is villages? The villages are nothing but sink of localism and narrow-mindedness and communalism. He argued that local government is den of ignorance. He was extremely critical of the local governments. But if he would have been alive today, his views would have been totally different. Right? Okay. So that is why Constitution has to be dynamic, and that is why the founding father of the Indian Constitution, they incorporated the provision about the amendment of the Indian Constitution in the Constitution itself under Article 368. अगर वो नहीं चाहते कि Constitution amend नहीं, हमने जो बोला वही Constitution है, उसको change नहीं करना है, तो Article 360, they would have not added Article 368. The very fact that they added 368 means they accepted that there might be inadequacies in the Constitution. There might be some issues which might have been ignored by the founding fathers of the Constitution, and that is why in future, the future generations should be able to change that, should overcome those inadequacies. Right? समझ में आया? Why do we need? This is very important because UPSC might ask you a question that why we need to amend the Constitution. What is the need? Now can you write answer? Very good. We have to write views of Dr. B.R. Ambedkar, Jawaharlal Nehru, and then you have to systematically write. Okay? Now, while talking about the salient features of Indian Constitution, I told you that there are different ways of classification of the constitutions. I told you that one way of classifying constitution is to classify them into codified and uncodified constitution. I say that to classify constitutions into written and unwritten constitution is misnomer, because all the constitutions are written for that matter. It's just that they are not codified. They are called as unwritten. For example, UK Constitution. So one way of classifying the constitution is codified constitution and uncodified constitution. Second way of classification of the constitution is democratic constitutions, undemocratic constitutions. India's constitution is democratic. China's constitution, North Korea's constitution is undemocratic. Right? Cuba's constitution, right? This is the second way of classification. Third way of classification, what is that? Federal constitution or unitary constitution. And I told you the fourth way of classification of constitution is rigid constitution and flexible constitution. Right? These are the two ways of classifying the constitution. I told you, right? Let me repeat for your revision, right? First is codified and uncodified constitution, right? Democratic and undemocratic constitutions, then federal and unitary constitutions, and rigid and flexible constitution. For this particular context, we will only focus on this type of, this type of classification. Now, yes, amendment to the constitution is required. It is necessary. But you cannot make the process of amendment of the constitution too easy. Why? Because if you make the process of amendment of the constitution too easy, then any ruling political party having majority in the parliament can change the constitution on the basis of its whims and fancies. So constitution cannot be too flexible. It cannot be the process of amendment of the constitution cannot be too easy. Now, what is flexible constitution? Flexible constitution is a constitution which can be amended by ordinary legislative process, and that too by single authority. For example, Constitution of UK is a flexible constitution. Why? Because the Constitution of UK can be amended by simple or ordinary legislative process. That is by simple majority. That is why it is called as flexible constitution. And the Constitution of UK can be amended only by one authority. It requires only one authority to amend the constitution. That is UK Parliament. So flexible constitutions are those constitutions, number one, which can be amended through ordinary legislative process and which requires only one authority for its amendment. These are called as flexible constitutions. Constitution of UK is example of flexible constitution. Then what about rigid constitution? Now, rigid constitutions are those constitutions which require, number one, special procedure for its amendment, and number two, it cannot be amended by only one authority. It can be amended only by more than one authority. Right? So you cannot say that rigid constitution is those constitutions which require special majority. No. There are two requirements. There are two things when we say that rigid, what is rigid constitution? Rigid constitution is that constitution, number one, which requires special procedure for its amendment, meaning it cannot be amended through ordinary legislative process, as in case of flexible constitution. Special procedure is required for its amendment, number one. Second, it cannot be amended by single authority alone. It requires the support of more than one authority for its amendment. For example, American Constitution is rigid constitution. Why? Number one, it requires special procedure for its amendment. The American Constitution can be amended by US Congress, which requires, and in US Congress, the resolution has to be passed by 2/3 majority. That is special majority. Right? Okay? But American Constitution cannot be amended by US Congress alone. That is one authority. It also requires another authority. That is the 3/4 of the state legislatures. Yes. Every amendment to the US Constitution has to be passed by both the houses of US Congress by special majority, that is 2/3 majority. Along with that, it also has to be passed by the 3/4 of the state legislatures. That is 38 out of 50 states के legislature ने has to pass. So two authorities are required. So American Constitution is rigid constitution. Why? Number one, it requires special procedure for its amendment. It cannot be amended through ordinary legislative process. Number one, and second, it can be amended. It cannot be amended by one authority alone. Flexible constitutions can be amended by only one authority, right? But the rigid constitutions requires more than one authority for its amendment. For example, US Constitution. Not only US Congress, but also by 3/4 of the state legislatures. All the amendments to the US Constitution requires support of not less than 3/4 of the state legislatures. There are 50 states. Out of 50 states, 3/4, 38 states had to pass that amendment. Then only that amendment will become operative or in effect. समझ में आया? Right? Now, Constitution cannot be too flexible. I told you that because then it will allow the ruling party, which enjoys simple majority in the parliament, by using the numbers, by using the numerical majority, the ruling party might destroy the constitution itself. If it is made too flexible. But if you made constitution too rigid, then I told you, then you are stopping the growth of the nation. Constitutions cannot be too rigid. You cannot make the amendment of the constitution too difficult process, so that virtually it cannot be amended. Why? Because I told you constitution is a dynamic document, right? So somewhere down the line you need balance between rigidity and flexibility. Constitution of UK is flexible constitution, whereas constitution of USA is rigid constitution, right? Now what about Indian Constitution? Now Indian Constitution is neither rigid nor flexible. Okay? Indian Constitution is neither rigid nor flexible. It is synthesis of both rigidity and flexibility. This was said by K.C. Weir, renowned constitutional expert. He said that Indian Constitution is neither flexible nor rigid. Indian Constitution is the synthesis of rigidity and flexibility. Got it? So Indian Constitution tries to seek the balance between flexibility and rigidity, which is a very good thing. So unlike British Constitution, Indian Constitution is neither too flexible, and unlike US Constitution, Indian Constitution is not rigid. Unlike UK constitution, it is not too flexible. Unlike US constitution, it is neither too rigid. It is a synthesis of both rigidity and flexibility. Now, how it is a synthesis of rigidity and flexibility, you will get to know after we discuss the process of amendment of the Indian constitution and types of majorities. Clear so far? Yahan tak clear hai? What is amendment? Why do we need amendment to the constitution? What is rigid constitution? What is flexible constitution? And what about Indian constitution? And the conclusion is Indian constitution is neither too rigid nor too flexible. Why? Let me give you answer and then you will realize why is it so. Why? Because there are some provisions of the Indian constitution, they can be amended through special majority, that is majority of the total strength of each house and majority of not less than 2/3 of the members present and voting. But there are certain provisions of the Indian constitution that can be amended through simple majority of both the House of Parliament, that is majority of not less than half of the members present and voting. But there are some provisions of the constitution which not only requires the special majority in both the Houses of Parliament, but it also requires ratification of not less than half of the state legislatures. So the type of majority to amend the constitution depends on which type of provision you want to amend. Right? Now I am going to explain what are the types of majorities. Okay, got it? Okay. Now let us discuss procedure of amendment and then I will discuss the types of amendment. Procedure of amendment. Now you have to remember all these steps. These steps are very, very important and UPSC has asked so many questions on this particular topic. Okay? So number one, I am not writing all those provisions. You just focus on what I am saying. Okay? Number one, to amend the constitution, constitutional amendment bill has to be introduced. Right? Okay? Now constitutional amendment bill can be introduced only in the parliament. It cannot be introduced in the state legislature. Okay? Right? So the process of amendment of the Indian constitution can be initiated by Indian parliament only. State legislatures, they do not have any role in initiating the amendment of the constitution. But there is one exception, and that exception I have already told you. That exception is Article 169. Article 169 states that Parliament may by law provide for abolition of legislative councils in the states which has such council, or creation of legislative council in state which does not have this council, if the legislative assembly of the concerned state passes the resolution to that effect by majority of the total strength of the legislative assembly and majority of not less than 2/3 of the members present and voting of that legislative assembly. So in case of creation or abolition of legislative council, the procedure can be initiated by the state legislature. But even in this aspect, the law has to be passed by parliament after the resolution has been passed by state legislative assemblies by special majority. Right? So even in that aspect, ultimately it is the parliament which has to pass law for creation or abolition of legislative councils. Right? So more or less, the process for amendment of the Indian constitution can be initiated by Indian parliament only. It cannot be initiated by the state legislature except one thing, that is Article 169, and that too state legislative assemblies cannot create legislative assembly or abolish legislative assembly on its own. After the resolution, the parliament has to pass law, right? So first thing is that the constitutional amendment bills can be introduced only in the Indian parliament. It cannot be introduced in the state legislature. Indian constitution has not given any right or any power to the state legislature to amend the Indian constitution. Now you can say that this is one of the unitary feature of the Indian constitution. No. Don't say wrong things if you don't know. Right? So only parliament has, only central government has power, because it's the central government which can introduce the bill, which will come up with the bill. So this is one of the unitary features of the Indian Constitution, that Constitutional Amendment Bill can be introduced only in the Parliament but not in state legislature. Okay, number one. Second, Constitutional Amendment Bill can be introduced either in Lok Sabha or in Rajya Sabha. It can be introduced in Lok Sabha, it can be introduced in Rajya Sabha as well. Okay? And this is the same case in with, this is the same as in case of ordinary bills. Ordinary bills can also be introduced in Lok Sabha or it can be introduced in Rajya Sabha as well. So similarly, remember, if there is a statement that Constitutional Amendment Bill can be introduced only in Lok Sabha, then this is wrong. Constitutional Amendment Bill can be introduced in either house of the Parliament. It can be introduced in Lok Sabha or it can be introduced in Rajya Sabha. Clear? Second, the Constitutional Amendment Bill can be introduced by a minister, or by a private member. Who are private members? Those who are not ministers. All the members of Parliament who are not ministers are called as private members, irrespective of the party to which they belong. So even the members of Parliament belonging to BJP who are not ministers, they will be called as private members. So Constitutional Amendment Bill can be introduced by a minister, that is government bill, but it can be introduced by private members as well. So private members can also introduce Constitutional Amendment Bill. Very important. So if there is a statement which says that private members cannot introduce Constitutional Amendment Bill, then this statement is wrong. Private members can also introduce Constitutional Amendment Bill. Got it? Okay? Then the third important thing is that introduction. Yes, anybody, any private member who is not a minister. So anyone can introduce Constitutional Amendment Bill, because either he will be a minister or he will be a private member. Any member of Parliament can introduce Constitutional Amendment Bill. Right? Whether he is minister or whether he is private member, doesn't matter. Got it? This is very important provision. Okay? Whereas in case of money bill, only ministers can introduce money bill. Only government can introduce the money bill. Private members cannot introduce money bill. Right? But Constitutional Amendment Bills can be introduced by a minister as well as by private member. Got it? Okay? Now next, introduction of Constitutional Amendment Bill does not require prior recommendation by the President of India. Okay? No prior recommendation by the President of India is required for introduction of Constitutional Amendment Bill. Okay? Got it? Did you write it down? Okay? So for example, we have seen that introduction of bill providing for admission or establishment of new states or formation of new states or alteration of area boundaries and names of existing states, it can be introduced only with prior recommendation of the President of India. But Constitutional Amendment Bill does not require prior recommendation of the President. It can directly be introduced. Money bill also can be introduced only in Lok Sabha, and that too with prior recommendation of the President. Okay? But unlike money bill, number one, Constitutional Amendment Bill can be introduced in Rajya Sabha as well. Money bill cannot be introduced in Rajya Sabha. And second, unlike money bill, introduction of Constitutional Amendment Bill does not require any prior recommendation by the President. Okay? Right? So let me summarize whatever I have discussed so far. Number one, to amend the Constitution, Constitutional Amendment Bill has to be introduced. Now, Constitutional Amendment Bill can be introduced only in Indian Parliament. It cannot be introduced in state legislature. Okay, number one. Second, Constitutional Amendment Bill can be introduced in any house of the Parliament. It can be introduced in Lok Sabha. It can be introduced in Rajya Sabha as well. Third, Constitutional Amendment Bill can be introduced by a minister or by a private member. Okay? And introduction of the Constitutional Amendment Bill does not require any prior recommendation of the President. It can be introduced even without the prior recommendation of the President. No prior recommendation of the President is required for introduction of the Constitutional Amendment Bill in Lok Sabha or Rajya Sabha. Got it clear? Now, how the constitutional amendment bill is passed. What is the majority required? Okay. Now we know that amendment of the constitution, article 368. Okay. Now the constitutional amendment bills has to be passed by special majority under article special majority by both the houses of parliament. Okay. Each constitutional amendment bill has to be passed by special majority by both the houses of parliament. What is special majority here under article 368? Here special majority means majority of total membership of each house, right? And majority of not less than, yes, 2/3 members of each house. Yeah, both houses, each house present and voting. So what is the majority required to pass constitutional amendment bill? The constitutional amendment bill requires special majority in both the houses of parliament. That is majority of total membership of each house and majority of not less than 2/3 of the members of each house present and voting. This is the majority of second kind, and I have already told you about this. Okay? Constitutional amendment bill introduced ho gaya. Now this constitutional amendment bill, after it's introduced, it has to be passed by both the houses of parliament through special majority. Got it? Now, next important thing. Constitutional amendment bills has to be passed by both the houses separately. Constitutional amendment bills has to be passed by both the houses of parliament separately. So it means that there is no provision of joint sitting in case of constitutional amendment bills. I repeat, constitutional amendment bills has to be passed by both the houses of parliament, Lok Sabha and Rajya Sabha, separately. There is no provision of joint sitting in case of any disagreement between both the houses. In case of any deadlock, there is no provision of joint sitting. Like in case of ordinary bills or financial bills, joint sitting can be taken to resolve the deadlock in case of ordinary bill and financial bills. In case of money bill, there is no requirement of joint sitting. Why? Because in case of money bill, Rajya Sabha has very limited powers. It has to pass it has to take any action within the 14 days. It can delay the money bill only for 14 days. And even if the Rajya Sabha does not passes the money bill, it will be considered as passed by both the House of Parliament. Okay? So in case of money bill, there is no question of joint sitting. Joint sitting is there for ordinary bill and financial bills. I am going to discuss legislative process in detail, but यहाँ पे सिर्फ इतना याद रखो, there is no provision of joint sitting in case of any disagreement between the houses over the passage of constitutional amendment bill. So what will happen if any of the house does not passes the constitutional amendment bill? What will happen? It will lapse. That constitutional amendment bill will not become an act. It will not be sent to the president itself. Right? So there is, because see how the disagreement can arise. Number one, the first house passes the constitutional amendment bill and second house rejects the constitutional amendment bill. This is the first way in which the disagreement can arise, deadlock can arise. Number one, first house passes the bill, second house rejects the bill. Second, first house passes the bill, second house returns the bill with recommendation, and the first house rejects those recommendations or amendments. Not recommendations, the amendments. Then also the deadlock will take place. Okay? Then what is the third? The first house passes the constitutional amendment bill, second house does not take any action for 6 months. Then also there will be a deadlock, right? So these are the various ways in which deadlock can arise, right? In case of constitutional amendment bill, if there is deadlock or disagreement between the houses, the bill will lapse. The bill will end. It cannot become an act because it cannot be sent to the president. It has to be passed by both the houses of parliament sitting separately, not through joint sitting. So there is no provision of joint sitting for constitutional amendment bill. Clear? Let me give you one example so that you will realize this. You will remember this. These examples are not mentioned in the books, but for the sake of your understanding, I am giving you. 24th Constitutional Amendment Bill was introduced in 1970. This bill was about abolition of privy purses. Abolition of privy purses. Privy purses used to be a benefits given to the formerly princes of the Indian princely states. Former rulers of Indian princely states used to be given the privy purses. Now Parliament, the Lok Sabha passed 24th Constitutional Amendment Bill in 1970, but Rajya Sabha did not pass it. Right? There was disagreement between the Lok Sabha and Rajya Sabha over this particular bill. And since Rajya Sabha did not pass this bill, that bill was lapsed. It was only later on when the disagreements between the Lok Sabha and Rajya Sabha was resolved, the government brought in new bill and then the privy purses was abolished. Okay? Right? Okay? Another example, very important example. You will remember this, okay? And that is 64th and 65th Constitutional Amendment Bills. They were introduced in 1989. 64th and 65th Constitutional Amendment Bill, Act nahi. Remember these examples, they are very important. They will help you in remembering this. 64th and 65th Constitutional Amendment Bill, 1989. Now 64th Constitutional Amendment Bill sought to provide constitutional status to Panchayati Raj institutions. And 65th Constitutional Amendment Bill sought to give constitutional provisions to constitutional status to urban local bodies. And both these amendments were introduced in 1989, just before the 1989 elections by Rajiv Gandhi government. Now, the 64th and 65th Constitutional Amendment Bills, they were passed by Lok Sabha, but they were rejected by Rajya Sabha. Because the Rajya Sabha members argued that this bill violates the federal structure of the Indian Constitution. And that's why the bill was lapsed. It could not become an act. It was only after the disagreements, the Rajya Sabha members were taken into confidence and the bill was later on reintroduced. And then after it was passed as 73rd and 74th Constitutional Amendment Act in 1992. Right? But the 64th and 65th Constitutional Amendment Bill, it was passed by Lok Sabha, but it was rejected by Rajya Sabha. And that's why there is no provision of joint sitting, I told you, and that's why this bill lapsed. Got it, the examples? So the moment you get any confusion between whether there is joint sitting or not, remember these examples, your confusion will be clear. That is why it is very important to study through examples, which are not given in your books. That is why you need teachers, by the way. Anyways, now, I told you that the constitutional amendment bills, they has to be passed by both the houses separately, not through joint sitting, and each constitutional amendment bill has to be passed by special majority in both the houses of parliament. Now, there are some constitutional amendment bills which affect the federal structure of the Indian Constitution. These constitutional amendment bills, they, along with the special majority in both the houses of parliament, they also have to be ratified by ratification of how many states? Not less than half state legislatures. I repeat, those constitutional amendment bills which sought to amend the federal provisions of the Indian Constitution, those constitutional amendment bills which affect the federal structure of the Indian Constitution. Such constitutional amendment bill not only requires special majority in both the houses of parliament, along with the special majority in both the houses of parliament, such constitutional amendment bills which affect the federal structure of the Indian Constitution also has to be ratified by not less than half of the state legislatures. Right? So what will happen in case of those constitutional amendment bills which affect the federal structure? First, the bill, constitutional amendment bill, will be introduced. It can be introduced in any of the house. No recommendation of president is required. Minister and private member can also introduce. Lok Sabha will pass, Rajya Sabha will pass. After that, the bill will not be sent to the president for his assent. The bill will be sent to the state legislatures. And only after half of the state legislatures ratify such constitutional amendment bill which affects the federal structure, the bill will be referred to the president. Got it? Clear? So here is the next step. After the constitutional amendment bill is passed by both the houses of parliament by special majority and both the houses of parliament with ratification of not less than half of the state legislature wherever required, the constitutional amendment bill is referred to the president. बिना सोच के क्या बोलते हो यार तुम? थोड़ा दिमाग लगाया करो. It irritates the teacher, no? Don't say wrong things. After constitutional amendment bill is passed by both the houses of parliament by special majority and wherever required by ratification of at least half of the state legislature, such constitutional amendment bill will not become an act. Such constitutional amendment bill will be sent to the president for his assent. Okay, right? Don't say that constitutional amendment bill will become an act the moment it is passed by both the houses of parliament by special majority. No. No bill in India can become an act without the assent of the president. That is why we say president is an integral part of Indian parliament. Article 79. The parliament, there shall be a parliament which shall consist of president and two houses, namely Council of States and House of the People. So don't say that president is not a part of Indian Constitution, right? So next step is, after the constitutional amendment bill is passed by both the houses of parliament by special majority and wherever necessary by ratification of not less than half of the state legislature, such constitutional amendment bill will be referred to the president for his or her assent. Wait, I'm coming to that. Now, what will happen? Now, once the constitutional amendment bill is referred to the president for his assent, it is mandatory. It is mandatory for the president to give his assent on constitutional amendment bill, on such constitutional amendment bills. Constitutional amendment bill, after being duly passed by both the houses of parliament by special majority and wherever required by the ratification of at least half of the state legislature, will be sent to the president for his assent. Now, President of India, he has to give his assent, his or her assent on the constitutional amendment bill. Giving assent to the constitutional amendment bill is constitutionally mandatory, compulsory to the president. It means that President of India cannot withhold assent. Yes? Over constitutional amendment bill, nor he can return the constitutional amendment bill for reconsideration of houses. See, in case of ordinary bill, president has so many options. He may withhold his assent. Withholding assent means rejecting the bill. President of India cannot reject constitutional amendment bill, nor he can return the constitutional amendment bill for reconsideration of houses, nor he can keep the constitutional amendment bill pending on his table. No. Once the constitutional amendment bill is duly passed by both the houses of parliament and wherever necessary by state legislature, half of the state legislature, president has to give his assent. It is mandatory, it is constitutionally obligatory and binding on the president to give his or her assent on constitutional amendment bills. Meaning he cannot withhold his assent, meaning he cannot reject constitutional amendment bill, nor he can return the constitutional amendment bill for reconsideration of both the houses of parliament, nor he can keep the constitutional amendment bill pending for indefinite period of time. Pocket veto, right? No. He has to give assent to the constitutional amendment bill. Now this requirement was not there in original constitution. It was provided through 24th Constitutional Amendment Act 1971. Remember this Constitutional Amendment Act. So 24th Constitutional Amendment Act 1971 made it binding on the president to give his assent on constitutional amendment bill. So before 24th Constitutional Amendment Act 1971, president could withhold the assent on the constitutional amendment bill. He could return the bills. But the 24th Constitutional Amendment Bill, 24th Constitutional Amendment Act 1971 made it obligatory for the president to give his or her assent on constitutional amendment bill. Right? So there might be a question that which Constitutional Amendment Act made it mandatory for the president to give his or her assent on the constitutional amendment bill passed both the houses of parliament or wherever required state legislature. That is 24th Constitutional Amendment Act 1971. So there might be statements. Consider the following statement. Number 1, President of India President of India has to or it is legally mandatory or it is constitutionally binding on President of India to give his assent to the constitutional amendment bills. Statement 1 is correct. Statement B, this provision was added through 42nd Constitutional Amendment Act 1976. Wrong. It is 24th Constitutional Amendment Act 1971, Indira Gandhi government. Got it? These are the provisions. So let me revise once again quickly. Number 1, constitutional amendment bill can be introduced only in the Indian Parliament. It cannot be introduced in the state legislature. Number 2, constitutional amendment bills can be introduced either in Lok Sabha or in Rajya Sabha, right? Okay. Third, it can be introduced by a minister or it can be introduced by a private member. Fourth, constitutional amendment bill does not require prior recommendation by the President of India for its introduction in any of the house. It can be introduced even without the recommendation of the President. Then each house of the parliament has to pass constitutional amendment bill through special majority. That is majority of the total membership of each house and majority of not less than 2/3 of the members of each house present and voting. Okay? Now both the houses of parliament, each house should pass the constitutional amendment bill separately. There is no provision of joint sitting. Now there are some constitutional amendment bills which require along with the special majority in both the houses of parliament, it also requires ratification of not less than half of the state legislature. Such constitutional amendment bill which affects the federal structure. Okay, right? Now after the constitutional amendment bill is duly passed by both the houses of parliament and wherever required by ratification of at least half of the state legislature, the bill will be sent to the president for his assent. Now once the president receives the constitutional amendment bill, it is constitutionally binding on him to give his assent on constitutional amendment bill. He cannot withhold his assent, nor he can return the bill for reconsideration of the houses, nor he can keep the bill pending on his table, right? And the 24th Constitutional Amendment Act 1971, it was this amendment which made it mandatory or constitutionally binding on the president to give his assent. Before this amendment, president had options. It had veto powers. But when it comes to constitutional amendment bills, president does not have any veto power. He has to assent the constitutional amendment bill, है ना? Because special majority से pass हुआ है दोनों houses में, ratification of the state legislature भी है whenever required. So president should not, ideally speaking, president should not withhold those bills, right? Or return the bills for reconsideration. That is it. We will continue with the amendment of the constitution in the next class, right? In next class, we will discuss about types of majorities. Types of majorities required for Indian constitution, right? So majority, type of majority, simple majority. Some provisions can be amended by simple majority, some provisions can be amended by special majority, and some provisions which affect federal structure, which can be amended by special majority along with ratification of half of the state legislature. Okay, right? Chalo, thank you.